This is a heads up for spoilers for the first season of The Lake on Amazon Prime. There has since been a second season uploaded, but I won't be discussing any of those plot points. Hi, this is Céleste, and this is Wait, Is That Legal? A podcast that comes from my own curiosity about legal questions raised in TV shows and movies to determine what would or should have happened in the real world. So join me, a real lawyer, as I try to offer legal advice to fictional characters in fictional scenarios using real laws. This podcast is not intended to offer legal advice to real people in real legal situations. It is just for fun. Imagine an old man faced with his mortality and trying to put his affairs in order before the end. His biggest worry is the fate of the family lake house. His second wife never liked it, and there was even talk of selling the cottage to buy a condo in Florida for her. His only biological child, his son from his first marriage, is estranged and living in Australia. His stepdaughter loves the cottage and relies on it as a familiar place for her family to spend their summers because they move around a lot as her hockey-playing husband gets traded. It would make sense to leave the stepdaughter the cottage. But then there is his biological granddaughter. This granddaughter is the only child of his son and the reason for their estrangement. The son gave up his daughter for adoption, which the man believed was unforgivable. And yet, now, at the end of his life, he wants to make it right, and maybe provide a means for that granddaughter to share in the family's legacy. So, the man names his second wife as his heir, but gives the lake house to his stepdaughter. But, in an addendum to the will, he puts the lake house property into a trust. The trust names the stepdaughter as the owner of the lake property until such time as she leaves the property permanently or her death. Then the son becomes the owner of the property. The man believes he has solved his dilemma, allowing his stepdaughter to enjoy the cottage, potentially for her entire life, and then allowing it to go back to his biological heirs. And it does work, up until the son returns to Canada and to the lake to get to know the daughter he gave up in an open adoption, and the stepdaughter wants to demolish the cottage to build a brand new structure on the property. This is the premise of the Amazon show, The Lake, starring Julia Stiles. In the show, Justin and his high school best friend give up the baby they had as teenagers to an open adoption. Justin leaves Canada as soon as he graduates and moves to Australia. He gets married there and only communicates with his biological daughter through video calls and emails. He is now divorced and decides to come back to Canada in order to make up for lost time with his daughter and to introduce her to the lake that he loved as a child. He then discovers that his stepsister, Maisie May, now owns his family's cottage, and she is trying to get a permit to do drastic renovations to the cottage built by Justin's grandfather. Justin does not want the renovation to happen, and the two step-siblings spend the summer fighting over the cottage. What interests do Justin, Maisie, Billy, and Maisie's kids, Opal and Killian, have in the cottage? Can Maisie alter the cottage, and can Justin stop her? These are some of the questions that we can answer by exploring the topics of estates and trusts. First, let's look at the issue of trust. A trust is a legal relationship where one party arranges for property to be held and managed by another for the benefit of a third party. The person who creates the trust is called the settlor or grantor, and they are the original owner of the trust property. The grantor creates the trust to benefit a third party or a class of people, known as the beneficiary or beneficiaries. The person appointed to manage the trust is known as the trustee. There are many kinds of trusts. Some are defined by how they are created, like a testamentary trust or a constructive trust, and others are defined by their purpose, like a charitable trust or a support trust. Express trusts are created with a specific purpose or beneficiary in mind. An express trust can be created during the lifetime of the grantor, known as an inter vivos trust, or be created within a will or as part of a deceased grantor's estate, like a testamentary trust. We will be dealing exclusively with an express testamentary trust, so I will not be expanding on the other types of trusts today. The biggest difference between an inter vivos trust and a testamentary trust is that while the grantor is still alive, they are usually still able to revoke or amend the trust at will. Because it is a trust formed by the grantor's death, then a testamentary trust is usually irrevocable, unless the trust document provides otherwise. Express trusts are usually formed by writing, but they could be created by an oral pronouncement of the grantor's intent. In order for a trust to be valid, there must be intent by the grantor to create a trust, the existence of the trust property, a valid purpose for the trust's creation, ascertainable beneficiaries, and a designated trustee. In the lake, the trust was created by Justin's dad, whom I will refer to as the dad from here on out, in an addendum to his will. The trust is made for the express purpose of preserving the cottage for Justin's heirs. So the dad created an express testamentary trust that is in writing. Ontario case law is very clear that the intent to create a trust is the most important factor in determining whether there is a valid trust. Here we know that the dad had the intent to create the trust because of the addendum's use of the magic words. That is, that he uses the word trust. This is above and beyond what the case law requires. The trust property exists because the cottage is a physical building on real property that was owned by the dad at the time of his death. As the original owner of the lake property, the dad is the grantor, and he is named Justin and Justin's heirs as the beneficiaries. By the time the trust was created, Justin was alive and ascertainable as a beneficiary. So regardless of the status of his heirs, the trust can exist for his benefit. The dad designated Maisie May as the trustee. There is an express purpose stated for the trust creation, to allow Maisie to enjoy the cottage, but for the property to ultimately pass to a blood relative. It is the implication of a dad wanting his biological heirs to inherit the cottage that might not be seen as a valid trust purpose. Generally, modern courts are hesitant to honor conditions in a will or a trust that names heirs of a body or blood relatives only. And this is because modern families come in all forms, and legal relationships are not always ones formed by blood. However, when it comes to writing a will, the courts will honor express terms even if they are discriminatory towards certain relatives. Basically, the difference between a will granting property to a specific child or children, but expressly disinheriting other children. For example, the family farm will go to Alice and Bob, but Charlie is not to inherit any portion of the farm. This can be contrasted with a will that says something like, "To my biological children, I leave the family farm, and to my adopted son, I leave nothing." Court would likely accept the expressly named version, even if it turns out that Charlie is adopted, and that's the real reason he has been left out of the inheritance. But when the will leaves it vague as to who the biological children are and who is the adopted child, the court would likely entertain challenges made to the will's validity. Basically, a testator is allowed to disinherit anyone that they want, biological children included. Or if the testator is particularly bigoted and tries to disinherit their gay son's adopted children and says something like, "I leave the family farm to my son and to my son's heirs of his body." In that case, the court would likely just strike out the heirs of his body language because the son's adopted children are legally his heirs, and it's kind of too specific to say that you want them to be biological children, because they are just his son's children. Here, the fact that the dad is trying to leave the cottage to his biological child, Justin, will not affect the validity of the purpose of the trust. Maisie is not mentioned once as having been adopted by the dad. She refers to him as dad, but it seems that everyone is in agreement that Justin and Maisie are step-siblings. This means that there is no legal relationship between Maisie and the dad. She is not a legal heir to the estate, and he really has no legal obligation to her. She has inherited a limited interest in the cottage only by being named as a trustee. The dad's legal heirs are his surviving spouse, Maisie's mom, and Justin, his only child. Although the dad only names his wife as his legal heir. So this was the dad's way of removing his wife from having any interest in the cottage that she never enjoyed visiting, and giving his stepdaughter a chance to enjoy the cottage before it would ultimately pass back into the dad's family. The interesting part of all of this is that Justin thinks that his dad was trying to ultimately leave the cottage to Billy, the granddaughter that the dad never met, but was upset with Justin for giving up for adoption. If this had been the real purpose of the trust, the dad needed to expressly name Billy as the beneficiary of the trust, because despite her being Justin's biological daughter, she is not legally his child or heir. This is for the same reason that Maisie is not the dad's legal heir. When a biological parent gives up their child for adoption, they have to sign away their parental rights. This is because the child is now part of a new family, and presumably they will inherit from their new parents, grandparents, etc. And it would be unfair and, frankly, illogical for them to also inherit from the biological family that severed ties with them. This is all made a lot more complicated by the fact that Billy is in an open adoption and actually knows who her biological parents are. With a closed adoption, it would be a lot more simple for biological family and the adopted families to completely sever ties, and there wouldn't really be the same confusion. Not to say that open adoptions are bad or anything, but it does make things a little bit more confusing. The lines are a little bit more blurred. So, of course, this does not prevent them from being named in a will by a biological family member. A person writing a will can leave their estate to anyone that they wish, from family members, friends, organizations, strangers, and even pets, so long as the court can identify who the entity is that is named and that they are real and alive. So nothing was stopping the dad from expressly naming Billy as a beneficiary of the trust, or including her in the will. She was already born when the dad died. Similarly, nothing would prevent Justin from writing a will and naming Billy as his heir. Billy would have to be expressly named as an heir in either situation to have any stake in the cottage, because she is no longer legally related to Justin or the dad. This is a valid trust, and because the grantor is now deceased, it is likely irrevocable. An irrevocable trust is exactly what it sounds like. It is a trust that cannot be revoked. This means that there is no way for the trustee or beneficiaries to dissolve the trust and access the trust property. Basically, an irrevocable trust allows the grantor to continue to control the trust property, even in death, which is the main reason why people form trusts to begin with. The trust is only ended if there are conditions in the trust document that terminate the trust or upon completion of the trust purpose. In the lake, the addendum is very clear that the ultimate purpose of the trust is to transfer ownership of the cottage to Justin. The trust will not terminate until Justin is given full ownership of the cottage, which the addendum provides will happen either upon Maisie's death or upon her abandonment of the cottage. Of course, because this is a legal concept, it's not always so concrete, and there are ways to revoke an irrevocable trust. But it would not be as easy as Justin and Maisie make it seem in the show. To revoke an irrevocable trust, there needs to be complete agreement by all the designated trustees and beneficiaries of the trust. Then that agreement would need to be signed off on by a judge. Before the judge agrees to dissolve the trust, there might be a hearing. Overall, the judge is going to have to decide if the grantor's intent and purpose in creating the trust is more important than the trustees' and beneficiaries' reasons for wanting to dissolve the trust. The dad's intent is completely rational and reasonable. Plus, it is a simple purpose to execute. The motivations of Maisie to keep the cottage, massively renovate it, and ultimately pass it on to her children, and Justin to cash out his future interest in the property so he can buy another property on the same lake, are not in keeping with the spirit of the trust purpose, nor are they even in either party's best interest. In particular, Maisie, as the designated trustee, would benefit much more from this arrangement, and Justin, as the beneficiary of the trust, is essentially asking to sell his stake in his family's cottage in order to potentially be able to buy a cottage on the same lake. I do not think that a judge would sign off on this agreement. And further, I think that Maisie, as the designated trustee, would probably be found in breach of her fiduciary duties as a trustee to preserve the property. The judge's decision might be different if Justin's motivations were different. For example, if he wanted to stay in Australia forever, or if he wanted to use the money to buy property somewhere else, the judge might agree and sign off. Usually, a trust is dissolved because the trustee no longer wants to manage the property, and the beneficiary would prefer to just have full access to the property now and not in the future. It is strange that Maisie and Justin thought that this is how the trust would be dissolved, especially since I think they mentioned that lawyers are even involved. In reality, if a judge agreed, the cottage would have ended up either being distributed to the intended beneficiary or being placed back into the dad's estate. Neither of these scenarios benefits Maisie, and she would no longer have any interest in the cottage. And surely that would have been something that her lawyer would have brought up to her. What happens in the show is that Maisie and Justin apparently sign an agreement, and before Justin can even tell Maisie that it's done, Maisie's mother shows up to take ownership of the cottage as the heir to the dad's estate. As her mother's only child, Maisie appears to be her mother's only legal heir, and would eventually inherit the cottage from her. But this is only if Maisie's mother doesn't sell the cottage, get remarried, adopt another child, or expressly disinherit Maisie. This scenario eliminates both Justin's entire interest and Maisie's present interest in the cottage, which is so wildly against the express purpose of the trust that no judge would have ever agreed to it. Plus, it all happens way too fast. The more likely outcome in the real world would be that the court would dissolve the trust and give the cottage to Justin, the beneficiary. This is simply an acceleration of the trust's purpose and is in keeping with the grantor, the dad's, wishes for the property. The better way that Justin and Maisie could have resolved this conflict would have been for them to just stick to the status quo, or for them to make an agreement that Maisie would abandon her interest in the cottage, which would then transfer ownership to Justin and terminate the trust. Then Maisie could buy the cottage from Justin, or do what Justin was planning and buy a different property on the lake. This would be risky for Maisie because Justin would not have to sell her the cottage if he didn't want to. But at least one of them would end up actually in possession of the cottage in that scenario, which a judge would likely agree to. Really, the best case scenario for Maisie would have been to stick to the status quo. She would have been able to enjoy the cottage for her lifetime and could have saved the money that she was going to use for the renovation, or that she was saving by not having to buy or rent a cottage after her stepdad's death, and given that money to Opal and Killian to buy their own cottage for after Maisie's death. Or in a totally wild out there scenario, because they're both still in high school, and actually Killian isn't in the second season at all, but maybe Billy and Killian, who were dating in the first season, end up getting married at some point. Justin ends up naming Billy as his heir, and then both families just end up owning the cottage in the distant future anyways. But, I mean, that's sunshine and rainbows, right? So, everyone's interests in regard to the trust are: Justin is the beneficiary of the trust. Maisie is the trustee and has control of the trust property insofar as to maintain it for Justin and Justin's heirs' future use. Billy has no interest in the cottage unless she is expressly named as Justin's heir. And even then, she would not have an interest until Justin dies. Maisie's husband and children have no interest at all. Maisie's mom has no interest in the trust. But if Justin were to die, as he seems to be in season 1, divorced, single, no legal children, and no surviving parents or siblings, then, barring a will naming his intended heirs, the trust property would have to revert back to the dad's estate. Maisie's mom, as the heir to the dad's estate, would then inherit the cottage. Now, let's go back to before Justin and Maisie blew up their interest in the cottage in order to explore the exciting world of defeasible estates. For the majority of the first season of The Lake, the main conflict involved a massive renovation project that Maisie had planned for the cottage. This made Justin upset because his grandfather built the cottage, and he doesn't want to see it changed. Maisie's plans aren't even just small upgrades. She essentially wants to tear down the cottage and build something new on the land. Armed with the trust document, Justin and Billy try to figure out a way to stop the renovation or to get Maisie to abandon the cottage to trigger the transfer to Justin. What no one seemed to ask was whether Maisie could even do the planned renovation, due to Justin's future interest in the cottage. To answer this question, we need to figure out exactly what kind of interest all parties have to the lake property and the cottage. In property law, when a grantor, the original owner of the property, conveys property all at once, totally intact and with no restriction, they do so in fee simple absolute, which is sometimes just referred to as fee simple. So if Owen, the original owner, and seriously, in law school, bar exam, and all legal examples ever, they always pick names that start with the same first letter as the position that they hold in the story. So Owen, owner. And all the properties are also in the form of a color plus acre. So we're going to use Blackacre. So if Owen owns Blackacre and wants to give it to his son, Abel, no strings attached, he would do so by stating in his will something to the tune of, I, Owen, grant Blackacre to my son, Abel. And technically that's all he has to say. It is implied that what it really says is, I give Blackacre to Abel and his heirs in fee simple absolute. As the owner of a fee simple interest, Abel has the full present and future possessory interest of the property, and the complete freedom to do what he wants with the property or to sell it. Courts prefer transfers to be in fee simple absolute because they prefer that property be freely alienable, which just means that it can be sold, leased, or used however the new owner sees fit. That being said, this is the law we're talking about, so nothing is ever quite as simple as fee simple absolute. This is going to get really detailed. Sorry about that, but I'm going to do my best to simplify it. Also, I have an Instagram for this podcast at Waitisthatlegal, and I will post some sort of infographic charts thing so that to try and sort of visualize the concepts, if that helps. So, there are 4 ways that a grantor can convey their property that puts restrictions on the grantee's interest. All 4 of these ways create both present possessory estates and future interests. The present possessory estates can be a life estate, fee simple determinable, fee simple subject to conditions subsequent, and fee simple subject to executory interest. The potential future interests are categorized as rights of reentry, reversion, possibilities of reversion, executory interest, and remainders. So, if Owen has a girlfriend, and let's just call her Gretchen, that he wants to provide for, but ultimately he wants Blackacre to go to his son Abel. It could take the form of I, Owen, grant Blackacre to Gretchen for life, and then to Abel. If Abel is Owen's only child and heir, it would be implied that he would get it when Gretchen dies, so he doesn't actually need to name Abel, but it's always good to be specific. This would be a life estate, where the property is devised to someone for the span of that person's life, and then the property either reverts back to the grantor's estate or goes to another named party. The future interest in a life estate is called a remainder. Alternately, a grantor can also grant a life estate for the period of someone else's life, and this is a life estate per ultra v. So let's say that Gretchen is elderly and being cared for by Gretchen's daughter, Barbara. Gretchen might need to be put in a care facility, but Owen wants to make sure that the property is available for her and that Barbara has somewhere to stay. Owen could give Blackacre to Barbara for so long as Gretchen is alive. After Gretchen's death, the property would revert back to Owen's estate, and Barbara would no longer have any interest in Blackacre. Life estates are sort of in between the fee simple absolute estate and the other defeasible estates because they have a lot less restrictions on the person who holds the present interest. For example, a life estate is transferable. So, in the example above, if Gretchen doesn't want to continue living at Blackacre, she can sell her interest to the remainderman, Abel, or to a third party. If she sells to the remainderman, then the life estate is over, and Abel would have the full fee simple estate. If Gretchen sells to a third party, then they are only receiving the interest that Gretchen has in Blackacre. So the third party is buying a present possessory interest in Blackacre for the life of Gretchen. When Gretchen dies, the third party would no longer have any interest in Blackacre. Life estates can also be treated like a fee simple estate and have defeasible interests attached. So now let's say that Owen and Gretchen are a bit younger, but both came to the relationship with children of their own. Owen's son Abel is already an adult and has moved out, but Gretchen's younger daughter Chloe is still a minor. Owen would like the house to go to his son, but he doesn't want Gretchen to have to move while Chloe is a minor. So Owen could give Blackacre to Gretchen until Chloe turns 18 and then to Abel. This is a fee simple determinable interest, where the estate terminates automatically at a named future event. In this case, that would be Chloe's 18th birthday. A fee simple determinable creates a possibility of reverter in the grantor, which is a future interest that allows the property to revert automatically back to the estate. Now, let's imagine that Blackacre is a centuries-old family farm, and Owen has been fighting local developers trying to buy the land. Owen's son Abel has already purchased an adjacent piece of land and is farming it. So Owen wants to leave Blackacre to Gretchen and her kids, but only if they continue to farm it. That would look like, I, Owen, grant Blackacre to Gretchen, provided she continues to farm the land. This is a fee simple subject to conditions subsequent. The grantor is conveying a fee simple interest in the land with a condition attached, and should the condition occur, the grantor has a right of reentry. If the condition never occurs, then the grantee will essentially have a fee simple absolute interest in the property. In this example, Blackacre is conveyed to Gretchen with the condition attached that it continues to be used as a farm. As long as Gretchen continues to farm the land, she has a fee simple absolute interest. If Gretchen tries to sell Blackacre to the developers, then Abel, as Owen's heir, has a right of reentry and can prevent the sale and retake Blackacre. If Owen wants Blackacre to remain a farm, or at least undeveloped, and he does not trust Abel to do so, he could do something like, I, Owen, grant Blackacre to Gretchen, so long as the land continues to be used as a farm. If it ceases to be used as a farm or is sold to developers, then Blackacre should be donated to the local 4-H chapter. 4-H is an agriculture and livestock organization for kids that's most often found in rural areas of the U.S. and Canada. So this is a fee simple subject to executory interest. The grantor conveys the property with a condition attached to it, but instead of the grantor retaining a right of reentry, the grantor names a third party as having a possible future interest. Here, Gretchen and her heirs have the present possessory interest in Blackacre, and they continue to have it so long as they farm Blackacre. The local 4-H chapter has an executory interest in Blackacre, and if Gretchen or her heirs stops farming or tries to sell Blackacre to the developers, then they can exercise that interest and take the property. And because 4-H is an organization, they can be ascertained for as long as they exist, and they would maintain the executory interest in Blackacre against all future owners of the property. In theory, anyways. Eventually, there would likely be a point where the court would no longer enforce the condition because it is a restraint on the alienability of the property. And actually, this topic gets way more complicated because there are all sorts of vested interests and the rule against perpetuities and all of that, but we're just going to leave that up. Not important. So, which of the previous types of present possessory estates does Maisie have? And what type of future interest does Justin hold? Using the addendum to his will, the dad granted the cottage to Maisie, essentially for life, but with the condition that should she abandon the property, that it would then go to Justin. Maisie has a life estate as a present possessory interest, and it is also subject to an executory interest. So long as Maisie is alive and using the cottage, she will maintain her life estate interest in the lake property. Should Maisie ever choose to abandon the property, which would likely also include trying to sell it, then she severs the life estate. Justin holds a future executory interest and is the remainderman of the life estate. He would automatically receive the cottage in fee simple absolute at the end of Maisie's life estate. If Maisie abandons the cottage prior to the end of her life estate, then Justin would have the right to take the property in fee simple ahead of the natural termination of the life estate. With a normal life estate, Maisie would have had the ability to sell her interest to someone else. But in this case, her selling the cottage would likely be interpreted as abandoning her interest in using the cottage, which would trigger the executory interest. As the holder of a life estate, Maisie has certain duties that all revolve around not harming the future interests in the property. These duties include general upkeep and repair of the property, paying mortgages and taxes, and the duty not to commit waste. Waste is any action taken by the present possessory interest holder, and here that's the life tenant, which adversely affects the future interests that follow the life estate. Common law has three main categories of waste, and they are voluntary, involuntary, and ameliorative waste. Involuntary waste is any purposeful act that affects or changes the property. Involuntary waste occurs by the life tenant's inaction, like failing to do repairs and maintenance, which allows the property to fall into disrepair. The failure to make mortgage payments, to pay taxes, or to deal with special assessments levied by the local authorities are also forms of involuntary waste. And ameliorative waste is an action that actually increases the overall value of the property, but negatively affects the remainder person's future interests. And at common law, waste was generally prohibited, and this is because it was assumed that the grantor intended the remainder person to end up with the land exactly as it was before the life estate happened. Although there were some forms of waste that were permitted, and these were usually in the form of voluntary waste, so especially in terms of natural resources on the property and waste committed in order to do repairs and maintenance. So generally, if the grantor had logging contracts in place, then those logging contracts could continue under the life tenant. And if there was a mining operation that had already begun under the grantor, then the life tenant can continue that mining operation, even though it is somewhat detrimental to the future remainder person's stake in the property. And also voluntary waste that's committed in order to do repairs and maintenance, generally allowed, considered permissible. At common law, ameliorative waste was not allowed, but modern courts generally do allow ameliorative waste to happen when the action does not impair the market value of the remainder person's interest, when the life tenant has the permission of the remainder person, or if there has been a substantial and permanent change in the neighborhood that has deprived the life tenant of the current value of the property. So an example of how far ameliorative waste can go is illustrated by the Wisconsin Supreme Court case decided in 1899, which notably is an American case, but is still grounded in common law property principles and I think is illustrative. In Melms versus Pabst Brewing Company, the court found that Pabst did not commit waste when they demolished the Melms mansion. Pabst had mistakenly believed that they owned the mansion in addition to the property that they owned around it. But it turns out that they only had a life estate per ultra V. The remainder men of the estate sued Pabst for waste because they would have inherited the mansion. The court found that Pabst had not committed waste because the property where the mansion stood was now much more valuable without the mansion. So Pabst had demolished the mansion because the upkeep costs and the taxes were more expensive than the property was worth, and the neighborhood had begun to rapidly industrialize. So Pabst ended up tearing down the mansion and building the Pabst Brewing facility on the Melms property and his adjoining land. The court stated that this was ameliorative waste, but that Pabst was not liable to the remainder men because the property had increased in value and was now being used in a manner consistent with the industrialized neighborhood. The Pabst case is unusual because, as a general rule, tearing down the residence on residential property would be considered waste. However, the Wisconsin court chose to look at the big picture and focus on the monetary perspective alone. And keeping the mansion was not a fruitful use of the land, and Pabst was losing money trying to maintain a residence in an industrial area. Not to mention that the future enjoyment of the property as a residence would also be affected, now that the house would be surrounded by factories and warehouses. So tearing down the house and building the Pabst Brewery was more in keeping with the common law idea of a life tenant using the land in a manner consistent with its fruitful use. There might have been a different outcome if the remainderman had sued Pabst before he demolished the mansion, and Pabst would have been liable for waste if he had bulldozed the mansion and built a brewery in a largely residential area, even if it turned out to be more profitable. The lake takes place in the Canadian province of Ontario, and according to the laws of Ontario, a life tenant is impeachable for waste and liable for damages to the party injured. Impeachable just means that they can be sued. Ontario also recognizes life estates without impeachment for waste, where the life tenant cannot be sued for waste. However, even without impeachment, the life tenant is not allowed to commit equitable waste unless it is expressly provided for in the document creating the life estate. And equitable waste is an English law concept that includes the types of permissible waste under common law, but allows that waste to be brought to a court of equity should the life tenant go too far. And going too far is very subjective, but it's essentially destruction that is inconsistent with the fruitful use of the land. So, for example, with types of permissible waste, particularly voluntary types of permissible waste, going too far might be, in the logging example, if the grantor has logging contracts, but those contracts are very specific as to how many trees or what tracts of land are allowed to be logged, and then the life tenant just goes and cuts down all of the trees on the entire property. I mean, that would definitely be going too far, and that would be equitable waste. Or in the mining scenario, if the grantor had a mining operation, but then the life tenant goes and opens another mine on the property and starts mining that as well, then that would be going too far. So courts of equity are distinguishable from courts of law because they focus on remedies that grant relief instead of compensation. So where a court of law would likely deal with waste by compelling the life tenant to pay the victim for the lost value of the property, a court of equity could issue an injunction to prevent waste from happening, compel the life tenant to restore the land to its original condition, or even end the life estate early in favor of the remainder person. And I mentioned that this is an English law concept and not a common law concept because in England they do have separate courts of equity and courts of law, whereas in the United States, which is also common law, those two courts are combined. So courts of equity and courts of law are combined into just the civil courts. So the remainder person of a life estate does have several remedies available when a life tenant commits waste. And these include monetary compensation for the loss in value due to the waste, or monetary compensation to repair damage done by either overt action or inaction, forcing the life tenant to restore the property to its original condition, or accelerating the passage of title to the remainder person by ending the life estate. So some examples of remedies for voluntary waste: if the life tenant, let's call them Lou, discovers gold on the property and digs it up, the remainder person, Ron, could sue for the decrease in the value of the property now that it has been excavated, and also for the value of the gold that Lou has dug up. If Lou is simply continuing a mining operation begun by the grantor, then Ron would have no remedy to stop the mining. And if Lou actually clears out all the gold in that mine, Ron still has no remedy or right to that gold. In an example of involuntary waste, if Lou fails to repair damage to the roof of the house and it eventually causes major water damage, then Ron can sue the life tenant for the decrease in the value of the house caused by that water damage, or for the cost of fixing the damage and repairing the roof. And an example of ameliorative waste, if all the houses in the neighborhood pave their gravel driveways and install solar panels on their roofs, and Lou also paves the driveway and installs solar panels, which ensures that the property value increases the same amount as the other houses, but Ron is upset because the paved driveway and solar panels will require more upkeep in the future. Ron will likely not be able to sue because the overall market value of the property has increased in line with the rest of the neighborhood, and it is not a change that alters the use of a property. How does all of this tie into the scenario in the lake? As the life tenant of the cottage, Maisie has the duty to pay all property taxes. The cottage has been in Justin's family for at least 2 to 3 generations, and it seems that the dad owned it outright, so there's likely no mortgage payments for Maisie to make. There is a lake board that seems to include all the properties on the lake, so there are probably dues that have to be paid, and Maisie would be responsible for those because she's generally a member of the board, and also because she believes that she inherited the cottage outright. She has probably been keeping up with those dues. Also, she has probably been keeping up with the bills and repairs. She does mention that she did repairs on the cottage. Maisie also has the duty not to commit waste, and this is the real issue because of the massive renovation that Maisie has planned. So Maisie wants to tear down the old cottage and basically build a new one in its place. And this would likely increase the overall value of the cottage because of all of the updates and the increase in square footage. But it is detrimental to Justin's future interests. So Maisie would be committing ameliorative waste. Justin likes the family cottage the way that it is because it has sentimental value to him. He has not given permission for Maisie to do her renovation, nor has the lake changed in any substantial or permanent way that makes the renovation necessary. From what we see of the other cottages on the lake, none of them are McMansions. I mean, it seems that that Justin's family cottage is maybe one of the bigger ones on the lake. There's some that have been renovated, and others that have not. And then there's the one lady that lives in a tent on her property. So it's not really in keeping with the character of the lake. Nobody is living in mansions. So if anything, Maisie is actually going against the current aesthetics of the lake. And there are multiple comments by other residents on the lake saying that they don't like the direction of the renovation. So tearing down the cottage would also be equitable waste because it goes too far by destroying the one thing that makes the property unique and what makes it special to the future interest holder, because it is the fact that the cottage was built by the grandfather that the dad wanted to keep it in the family. Justin's only course of action would be to petition a local court for an injunction, which would prevent Maisie from tearing down the cottage. The trust aspect of this situation would probably bolster this remedy, because the dad put the cottage into a trust to preserve it for Justin, and tearing down the cottage would run contrary to the stated purpose. Not to mention that as the trustee of the property, Maisie also has certain duties that involve maintaining the trust property in favor of the beneficiary. Also, it just doesn't make sense for Maisie to commit the resources to the renovation. As Justin points out, she would just be spending the money for the benefit of Justin's heirs, because once she dies, it will not be passed on to her kids. This should be especially troubling for Maisie because it seems that Opal is doing most of the design work, And though he may just enjoy the design process, he will only get to enjoy the finished product for a limited time, because he and Cillian have no future stake in the cottage. Also, any of the time that Maisie and her family have to spend not enjoying the cottage because it is under construction is ultimately just wasted, because they have a time limit on their enjoyment of the property. So, what interest do all parties have in the cottage? And can Maisie go through with her renovation? The cottage is the property of an express testamentary trust created in writing by the dad as an addendum to his will. The trust is likely irrevocable because the original settlor is dead. Justin is the beneficiary of the trust and Maisie is the designated trustee. The stated intent behind the trust is that Maisie can enjoy the cottage for the rest of her life, and at the time of her death or her abandonment of the cottage, the trust property is transferred to Justin and Justin's heirs. Maisie was given a present possessory interest in the cottage in the form of a life estate subject to executory interest. So long as Maisie continues to enjoy the cottage and make use of it, she will have possession of it until she dies. Should she abandon her interest in the cottage at any time before her death, then the executory interest would be activated. Maisie's kids, Opal and Cillian, and Maisie's husband have no legal interest in the cottage. They can enjoy it as guests of their mother/wife for as long as she continues to enjoy the property or till she dies. But beyond that, they are no longer entitled to any part of the cottage. Justin is the remainderman of the life estate and holds the executory interest in the event the life estate terminates early. Justin's heir also hold these future interests, but currently Justin does not have any legal heirs. Billy is Justin's biological child, but she is adopted, so she no longer has any legal ties to Justin. If Justin writes a will and names Billy as the heir to the cottage, then that would give Billy a future interest in the cottage. But that doesn't seem to have happened, and he seems to believe that Billy is his heir and still has legal rights of inheritance as his biological daughter, but he is sadly mistaken, and she will lose out if he doesn't do something about it. Maisie's mom has no interest in the cottage unless Justin dies without heirs and his remainder and executory interest revert back to the dad's estate. Maisie and Justin's attempt to revoke the trust would not have been successful because it would have taken a lot more than a handshake and a bet, and more even than a signed piece of paper to revoke an irrevocable trust. The trust has a clear purpose and an ascertainable beneficiary, so the only way that it could be revoked would be if a judge agreed with Maisie and Justin's agreement, which is just not likely. And finally, Justin might be able to get an injunction to stop Maisie from demolishing the cabin, but he wouldn't be able to stop her from making changes and improvements within the current structure. Any money that Maisie puts into the cottage at this point will benefit her enjoyment of the cottage and Justin's future enjoyment. Her kids and husband cannot recoup those costs, even if it increases the value of the property, because it would just be a milliard of waste. Overall, the deal that Justin and Maisie make would not have been in either of their interests. Justin wants the cottage to stay at on that lake to be connected to his family history and to create new connections with his daughter, Billy. Maisie May wants a cottage as a home base for her family in the hockey off-season, and that will be passed down to her sons to enjoy with their future families. She also wants to be able to design and build her dream house and let Opal be a part of that process. So the easiest solution here is to let Justin have his family's cottage and for Maisie to buy land on the lake to build a new cottage. And of course, this all could have probably been avoided if the dad had been more upfront about his intentions for the cottage. thank you for listening. The show is researched, written, and reported by me, Céleste Young. None of the legal advice or opinions expressed in this episode are intended as specific or individualized legal advice. Please like, subscribe, rate, or review this podcast if you enjoyed it. If you have any questions or comments, please email them to waitisthatlegal@gmail.com. You can find the podcast on Twitter, Facebook, and Instagram. Again, wills are very important when you have assets you want to control the future of. But it is also important to make sure anyone involved is aware of what those intentions are.